Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. There's a new whistleblower program in town, this time from the Department of Justice. On August 1st, the DOJ launched the Corporate Whistleblower Awards Pilot Program, a 3-year initiative. Epstein Becker Green's Greg Keating tells us what this means for employers.
George, this is really a big deal for private employers as it represents expansion of government enforcement in the whistleblower space. For example, private employers in the healthcare insurance space and also financial institutions dealing with bribery and money laundering issues are now covered by this program. Whistleblowers are likely to be coming forward more often, and employers need to step up their enforcement and compliance efforts.
This program is modeled on the SEC's Dodd-Frank program, aiming to fill the gaps where coverage doesn't exist. But Greg tells us there are some important differences.
Two principal ways it's different. The first is under other programs, such as the SEC's program, those who are part of the wrongdoing can nonetheless be a whistleblower. The SEC has used the expression, "we will use a rat to catch a rat." This DOJ program excludes from coverage those who are part of the wrongdoing. Second, those employees who are often known as trusted employees, those in compliance and in-house legal, in other programs, they are covered. Under this program, they are not covered as whistleblowers. So that limits this a little bit.
This new program comes in the midst of a nationwide uptick in workplace grievances and complaints. How should employers respond?
This program highlights the critical need for employers to act promptly and investigate every complaint immediately. Under this program, an employer has 120 days to investigate a complaint, and if there is in fact wrongdoing, to potentially self-disclose and avoid prosecution. That's a really short period of time, and employers really need to double down on their investigation protocols and commit to investigating every complaint promptly and effectively. The right time to bring in outside counsel is when there is even a hint of any type of illegal conduct, or if the allegation involves a senior executive within the organization.
Thanks, Greg, and thank you for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.